Is my microphone on?
Closer.
Good morning. Good morning. Okay. Thank you everyone for being here. We're very excited to be sharing our morning with you. And from here on, I'm going to get started the way that I would in court, okay? So welcome to the First District Court of Appeals. Today is Tuesday, October 31st. We have two cases on the docket this morning. Both will be arguing this morning. Attorneys, when you hear your case, if you can please state your name and your readiness to proceed. The first case that we have for argument is case number C230061, State of Ohio versus McCray.
Good morning, Your Honor. Jay Clark, Commissioner Gray, I'm ready.
Thank you.
Good morning, Your Honor. Keith Stoddard for the state ready to proceed.
Thank you. Thank you. The second case we have for argument is case number C230065, Samuel Voss versus Quicken Loan LLC et al.
Good morning, Your Honor. William J. for the appellants ready to proceed.
Thank you.
Good morning, Your Honors. Bill Markovitz on behalf of the appellee, ready to proceed.
Thank you. Attorneys, are you going to be coming up to the podium to argue up here?
That's our understanding.
Okay, all right, no worries. So if you can go ahead and just be careful as you're coming out. Good morning, Attorney Clark. How are you doing this morning?
Good morning, Your Honor. May it please the court?
Do you want to reserve time?
I would. Can I reserve 5 minutes for rebuttal, please?
Whenever you're ready, you can get started.
Just so I'm clear, are somebody who's keeping time?
I'll be keeping time.
All right. Thank you.
Just like in court, there won't be a big flag, there won't be any fireworks.
There might be fireworks.
Okay.
Your Honor, the juvenile court erred in failing to follow the very clear and unambiguous language in Revised Code 2152.121 when it allowed the state to file out of time an objection to the imposition of an SYO sentence following a reverse bind over Mr. McCray.
Mr. Clark, does Juvenile Rule 22E apply?
I don't think so, no.
Okay.
I think the case law looking at 2152.121 says it's clear, it's unambiguous, the language in the statute, and to ignore that language is plain error. When you look at the difference between Rule 22 that would allow some discretion and the statute, this statute is part of a bigger scheme of the SYO legislation the General Assembly enacted. In that statutory scheme, it allows for discretion in some cases by its terms, and in this case, particularly this section, does not. So I don't think the motion or the rule of Juvenile Rule 22 is applicable.
Thank you.
Counsel, I know your opponent plans to argue that this should never have been remanded back to the juvenile court in the first place. Can you address that aspect of the case?
Yes, Your Honor. The state's argument is that because the murder that was the bind over subject to the mandatory provisions was reduced to involuntary manslaughter, that offense of involuntary manslaughter in a firearm specification would also be subject to a mandatory bind over. However, that argument is flawed because the Ohio Supreme Court in State v. Hanning said that the complicity aspect of firearm possession does not apply to juveniles. In other words, for it to be a mandatory bind over of a Category 1 offense, the juvenile has to be the principal offender. In this case, DeMarion was not. It's undisputed that he never had a gun at all during any of the events relevant to this case. From his driving down to the scene with the other co-defendants, he watched them, he didn't participate, and then they drove away from the scene together. Because he did not have a firearm, he was not a principal offender.
And what about the specification that he pled to? How does that factor into the analysis?
The difference is this. Once he's bound over, he's subject to the laws that would apply to any adult. Complicity in terms of firearm specification for adult does apply in terms of sentencing. In other words, if you and I rob a bank and I have a gun and you don't, you're still responsible and held liable for, and can be sentenced for, the firearm specification because I had the gun. The reasoning in Hanning says that doesn't apply because juveniles are subject to being led or coerced, not in that sense, but maybe by misguided adults. So they do not hold a juvenile to the same level for the firearm possession as they do an adult. So for sentencing purposes, in the general division, he did get a 3-year gun specification. But for practical purposes, for the bind-over aspect of it, it would not have been mandatory because Hanning says that a juvenile is not responsible unless they are the principal offender, in other words, have the firearm themselves.
And does that explain why the state, in effect, conceded at the adult court level to the reverse bind-over?
Exactly why. When that plea was negotiated, it was the law we were operating under in the general division. He's subject to the 3 years for the firearm specification. It has to be part of the plea because it's mandatory. Bind-over it's a different consideration, and that's why when we're in the general division, there was an acknowledgement, I think, even by the court, that now it has to go back to juvenile court for the reverse bind-over. I think it's very clear that the state did not meet its obligation. The state conceded it and filed an objection. They blamed the court for docketing it incorrectly. They blamed the defense counsel because it had to be continued. I think arguing that a label on a docket is what puts the prosecutor on notice of what they have to do is a red herring.
But aren't they in essence arguing that it's a clerical error?
I couldn't hear you, I'm sorry.
Aren't they in essence arguing that it's a clerical error that resulted in the untimeliness?
No, they never made that assertion until the juvenile judge, when the case went back on the second day in June, said, I looked at the docket, it looks like it was docketed for amenability. I understand why the state didn't file an objection. The state never argued that that was the reason. If you go back and look at the relatively short transcript, they just say, we've never done it this way. In the past, when it came back, we just told you we wanted you to send it back, and you send it back. And that's when the prosecutor admitted she had not read the code section. A clerical error on a docket is not what puts any of us on notice who practice law. I have an obligation to know that the code, the prosecutor has an obligation to know the code. If the docket had said trial, it's sent back for trial, surely the prosecutor wouldn't have prepared for a trial.
But even if I were to agree with you and all of that were true, okay, isn't the trial court's jurisdiction and authority to determine that? And if the trial court determines that there was a clerical error, that would be a finding of fact that we would be bound to?
I don't think she, can you rephrase your question?
Okay, so let's say that we agree with your argument there, okay?
Yes, ma'am.
Ultimately, the trial court, as the trier of fact, would make that determination as to what led to the moment, right?
Okay.
So wouldn't we be bound to that?
I don't think so, no, because there's no evidence in the record to support it. I think you have to have some deference for the trial court's findings of fact if they're supported by some factual content in the record. But here there isn't any. The bottom line is they had almost twice as much time to file an objection to an SYO sentence because the general division court was almost 2 weeks delayed in putting its entry on remanding the case back to juvenile court. From there, they took another 18 days before they put anything on paper. None of that has anything to do with the docket. That the event that sent it back wasn't on the docket. The plea wasn't on the docket. What we have to follow is the code sections. And that's what the state should have followed. It didn't. It admitted it didn't. And it has no reason for it. And then, probably more importantly, from a legal perspective.
So you're saying that the trial court has no discretion when the state fails to meet a timing obligation?
When you say trial court, I want to make sure that we're talking about the same thing. You mean in this case, the juvenile court?
Correct.
I'm saying that the juvenile court judge has as much discretion as the statute allows. In this particular code section, 2152-121, there is no language that allows for discretion. This court, in the case of JP, I believe it was, talking about the way SYO proceedings can be instituted, cited to the code section that allows the court to, it can do 1, 2, 3, or 4, or extensions for good cause shown. In other words, when enacting the SYO legislation comprehensively, the legislature put in that code section discretion. In this code section, they did not, clearly indicating that they know they have the ability to put in discretion for a trial court and chose not to in this case. There's another example in this code section 2152.121 where there's no discretion also, and it says that once it's remanded back, if the court orders an amenability hearing, the juvenile cannot waive that hearing. So the SYO legislation in general has a lot of safeguards in it for a very specific reason, a very specific purpose, because we're dealing with juveniles, not adults. So the answer to your question on these facts in this case is no, that's my argument. The juvenile judge did not have discretion here because she was not given that by the statute. And in other statutes in the same piece of legislation on different issues, there is built-in discretion for the trial court. That's why it was error for her to accept and allow the out-of-time
So
objection.
your argument is premised that these statutes are written with the default being a lack of discretion beyond, if anything is untimely or if any procedural errors occur. That's the default.
I don't know that I would put it that way as a default. I think what we have to do is look at the language in whatever particular code section we're applying at the time. In this one, there's no discretionary language. In another portion of the same package, there is discretionary language. So my default is we have to follow the clear and unambiguous language of the particular code section unless told otherwise.
And Attorney Clark, I want to bring you back to the mandatory or discretionary nature of the bind over on where it was on remand, okay?
You mean the reverse bind over?
Okay, correct.
Okay.
Correct. And I understand your argument. And let's say that the panel disagreed with your argument and for some reason found that it wasn't a mandatory, it wasn't mandatory in nature when it was in the reverse bind over at that point in the procedural posture, okay?
Okay.
Wouldn't that be an issue of then jurisdiction? Because the jurisdiction of juvenile court is statutorily based. So if on the reverse, if it wasn't mandatory, then wouldn't simply the court didn't have jurisdiction at that time?
I want to make sure I understand what you're asking. When the general division remanded it back, if you agree with the state that it never should have been remanded back, did the juvenile court have jurisdiction?
Correct.
I would agree with that, because if it's not properly remanded back, we never did. The juvenile court doesn't have, and I think there's a lot of case law that kind of makes the point, but on the other side, where the general division imposed a sentence and the person shipped off to the Department of Corrections, and they should have remanded them back. They didn't have the authority to do it, so it makes sense that if they shouldn't have remanded them back, juvenile court would not have had authority.
I appreciate your response to that.
How am I on time? I feel like I'm close.
You're close. I'll give you another minute, and of course, if the panel has any questions.
What I'll do is, unless you have questions, I'll reserve the remainder for rebuttal.
All right, thank you. Good morning, Attorney Sauter. How are you?
I'm doing fine. How are you, Judge?
Good, good.
May it please the court, Mr. Clark. Let's see. With all due respect to Mr. Clark, this simply is not a Hannon case. When this case was transferred to adult court, there was a plea agreement that was entered into. That
Well, Mr. Sauter, I'm gonna, before you go into that, I just wanna get your take.
Yeah.
So at the trial court level, didn't the state invite that error?
Well, I think both sides were operating under a misapprehension that this was required to go back to the trial, to the juvenile court. But I think under these circumstances, I think what the court was getting at earlier about the jurisdictional issue of having to send it back to juvenile court, I think any invited error would be inconsequential in this case, because Pursuant to the plea agreement, as the court knows, Mr. McCrae entered a guilty plea to a reduced charge of involuntary manslaughter, and he entered a guilty plea to the fourth count, or the fourth specification of the first count, which specifically says that Mr. McCrae had a firearm on or about his person or under his control while committing the offense, the reduced offense of involuntary manslaughter, and displayed the firearm, brandished the firearm, indicated that he possessed the firearm, or used it to facilitate the offense alleged in count 1 hereof. And in conjunction with the plea agreement, the 1-year specification that would be under what Mr. Clark calls the complicity theory was dismissed. Under RC 2151.12A1B2, all of the check marks are all of the requirements for a mandatory bind-over or check here. The defendant was 17.
Can you address what I understand Mr. Clark's argument to be about the specification, which is that it's really a form of sentencing enhancement and that it doesn't go to the factual allegations in the case regarding whether DeMarion actually brandished or used a firearm?
Well, yes, Your Honor. I think under the plain reading of the statute, there is no indication that there was an exemption for a complicity theory. And I think once a guilty plea is entered to count 4, or a fourth specification in this count, any preliminary discussions about Mr. McCrae not having the firearm on his person are waived. They're subsumed, or they're superseded by the guilty plea in this count. And I just don't see any indication in either the statute or in Hanning itself to indicate that once there's a guilty plea to the 3-year firearm specification, that the provisions of RC 2152.12 no longer apply. And I think that's what we have in this case. It's kind of a procedural muddle where things probably weren't done according to the way they should have been. But I think the ultimate outcome was correct. This is the outcome that the parties intended to have. They entered into this agreed sentence thinking that Mr. McCrae would have a 9-year sentence with a 3-year firearm spec, and that's exactly what happened, whether there was a proper return to juvenile court or not. And I think that's what the court should focus on.
Does it matter if we look at, for the reverse bind-over inquiry, are we supposed to be looking at legally the use of a firearm or factually the use of a firearm, and what directs our attention to either one of those things?
Well, I think it's both. I mean, I think that once there's a guilty plea to the fourth count of the fourth specification under the first count, I think it's both a legal and a factual determination that he actually possessed, brandished a firearm within the meaning of the 3-year firearm specification under 2941.1545A. If there had been some mistake about this, or some question about it, he could have entered a guilty plea to the third specification, which would have been the complicity theory, or the 1-year specification. And that's not what happened. He entered a guilty plea to the fourth spec. The third spec was dismissed, and I think that's where I don't want to say that's what we're stuck with, but I think that's what was the intent of the parties, and that's exactly what happened. So I see no reason to reverse the.
If I understand your argument, what you're saying is what's going to govern is the charges, but I'll say the charges, as they stand at the plea moment,
Right.
as opposed to as they stood upon charging and when they were initially within the jurisdiction of the juvenile court.
That's exactly right, Your Honor. It's a negotiated plea. The entry of a guilty plea to the fourth specification.
And in essence, you're asking us to apply the general principles of a negotiated plea to this issue.
Absolutely, as well as the well-settled proposition of law that a guilty plea renders any factual dispute about the underlying allegations waived.
Mr. Sauter, first of all, can you speak up just a little?
Oh, I'm sorry, Your
That's
Honor.
okay, that's okay.
Here we go. Much shorter than Mr. Clark.
And Mr. Clark argued that because this is a juvenile issue, the analysis changes. And that's what Hanning stood for.
Well, Your Honor, the statute is written with the specific requirements, and I don't think anything that was said in Hanning changes that. I don't understand how the Hanning theory of complicity would have any bearing on this case at all when there's been a specific guilty plea to the three-year spec. It's the requirements or the strictures of RC 2152. 12A1B2 couldn't be any clearer, and it doesn't permit an inquiry into the underlying facts certainly when there's been a guilty plea to the 3-year firearms spec.
So was everyone just confused, including the trial court judge, or what happened?
Whatever comment I would have on that wouldn't be revealed in the record, Your Honor. I honestly don't know, but I know that looking at it from what is in the record, that the trial court got it right. It went a long way around to get there, but I think we have the right result in this case.
And if we get back to juvenile court, can you address the issue of the time?
Well, Judge, I think normally the juvenile rules would supersede whatever's written in the statute, and I understand Mr. Clark's distinction that he makes about certain portions of the statute having giving the juvenile court leeway, but in general, the juvenile court can follow its own rules, and they generally do supersede what's written in the statute because they're codified by the Supreme Court. And in this case, I think the juvenile court recognized that there had been some procedural problems with docketing issues and that sort of thing. And the 5 days, I argued in the brief that it wasn't prejudicial in this case. And what I mean by that is not as to the ultimate outcome of the case, and I understand what Mr. Clark means about that. But just in terms of the procedure that was used, the 5 days didn't make any difference in how the case was processed, and I think that the juvenile court got it right in terms of the timing. If we do properly get back to juvenile court under these circumstances, it would be our contention that we do not.
Is there anything in the record prior to the filing of the written objection to suggest that the state intended to object?
Absolutely, Your Honor. Everything that was indicated both in at the common pleas level and in the proceedings before the juvenile court indicated that that we were going to file the SYO objection, that this case was going to end up with an adult sentence, and that the plea was going to be effectuated. And I think both sides operated under those assumptions.
Are we to look at excusable neglect? Is that how we should view this?
Your Honor, if we do get back to the
Let's
court,
assume that we are.
I suppose, but I think it's I understand that the concession in the record that the prosecutor was unaware of the timing, but once again it was a minimal delay, and there were extenuating circumstances regarding the problems that the clerk had docketing this thing.
Well, it didn't sound like that was the reason that the state didn't file it.
No,
I mean,
right.
She admitted that she hadn't read the statute.
Right, I understand, Judge, and I fully acknowledge that. I still say that everybody got a fair shake nonetheless.
And if you can address, going back to the timing, the state's position on whether the trial court, the juvenile court, had any discretion to act beyond the 5 days.
Well, two things, Your Honor. First of all, there's nothing in the statute about the timing of the objection to indicate that it's jurisdictional, that the juvenile court can no longer consider an objection after the 14-day period. And second of all, I go back to what I was talking about before, that in general, the rules of practice will supersede a statute, and the juvenile rules do give the juvenile court ample discretion to easily give discretion to give an extra 5 days. So I don't know if the court heard my answer to that case, but
If you want to repeat it.
No, I was just saying that in any event, that the juvenile court certainly was within its discretion to give an extra 5 days, and there's been no showing that that procedure itself resulted in any prejudice to the defendant in this case. Unless the court has any questions, I would just ask the court to affirm the judgment of the trial court.
Thank you for your argument.
Thank you.
And thank you for joining us this morning.
Thank you.
Your Honor, Mr. Souter just said that he doesn't think the offense that was pled, the involuntary manslaughter, should have been sent back, that it's a mandatory bind-over. And you ask if that's a factual issue or not regarding the offender, in this case, Marin, having a firearm on him. There's absolutely no doubt when you look at the record from juvenile court and the general division that Marin did not have a firearm on him at the time of the offense. When you read Hanning very clearly says, if I had my glasses, because we conclude that revised code 2151.26B4 is the narrow exception to the general rule of judicial discretion, and because the plain language of the statute does not provide for imposing an accomplice's liability onto the juvenile, we hold that a mandatory bind-over provision, and it gives a code section, does not apply unless the child himself or herself had a firearm on or about their person, blah, 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 blah. What that says is, and what I think the state, I'm hearing him argue, which doesn't make sense, had he been charged in juvenile court with the same offense he pled guilty to, involuntary manslaughter and a 3-year gun specification, he still would not have been a mandatory bind-over candidate because he factually did not have a firearm. The only reason that he has to plead to that in the general division is because in the general division for adults, accomplice liability does attach. So when you're looking at a reverse bind-over, the question is the offense that the person pled guilty to, would that have been subject to mandatory bind-over in the first place? The answer here is no. Clearly no under Hanning. If you take the state's logic, anytime there's a bind-over that's mandatory, that gets reduced, and there's a firearm that the juvenile does not possess, it turns the reasoning on its head as to why we don't impose accomplice liability on juveniles. It does away with that. So to say that had he pled to this offense, had he been charged with this in juvenile court, it would have been a mandatory, is not accurate. It would not have been, and that's a factual determination.
Counsel, does this distinction between legal and factual liability explain why you had a defense attorney, a prosecutor, and a trial court judge agreeing to remand the case back to juvenile court? Exactly.
At the time we're in the general division, for lack of a better word, we're playing by general division rules. At that point, it doesn't matter accomplice liability or not under the juvenile because he's been bound over. But once the plea is entered and he's found guilty, the question is the offense of conviction one that would have been mandatory had it been charged in juvenile in the first place? And here the answer is no. And I think you have to read Hanning and the clear desire to not give accomplice liability to juveniles. You have to give it its meaning, and that's exactly what it means. When it goes back to juvenile court, it would have been a discretionary bind over the way he pled.
So is your position that we have to look behind the guilty plea to the actual facts of the case to assess whether it's eligible for reverse bind over?
I think you have to look at the facts to answer the question, had he been charged, had the juvenile been charged in juvenile court with the offense of conviction and the facts that support that offense, would it have been a mandatory bind over? Here the answer is no, because he was not the principal offender. He did not have the firearm. If factually he did have the firearm, I agree with the state. It would not have been a reverse bind over because it still would have been a mandatory bind over as a category 1 offense, I believe, so you don't ever get to amenability.
So if in understanding your argument and the state's argument, I'm going to put those two together, all right?
Okay.
And let's see how you feel about my question, all right?
Probably not going to like it, I don't think.
I think you're going to like this one.
Okay.
All right? So it sounds to me that what you're saying is what would have been required in order for it to be a discretionary bind over on remand and then not be remanded is that at the time of the plea, that the plea would have included a recitation of facts that would have changed the facts as they actually were when the charging took place and when the offense took place?
I think I understand you're asking me at the time of the plea if the record had been made, I'll say more complete or better, rather
Well,
than
if
just...
the record had included a recitation of facts that the juvenile would have been agreeing to at that time.
That, I would agree
Which, you
that-
know, that happens, I don't want to say all the time.
No, I
but, you know,
understand.
it happens for restitution purposes, it happens for all kinds of things.
I agree with you, and I think, and I don't remember which made the comment to Mr. Souter, was just basically everybody was wrong in the general division. And I don't think it's a question of everybody being wrong. I think everybody understood that it's an involuntary manslaughter. He was not the principal offender, never any question about that. And as a result, once the plea is entered and he's found guilty, it gets remanded back. And I think you're right. The failure, if you will, was to make a record making that clear.
So
But
what
I-
you're saying is what was actually pled to is not going to cover the facts of the case unless there's a recitation of the facts of the case that changes it at that time at the plea stage.
I agree with that because I think at a minimum at the plea, you have to have basically the elements of the offense that you're admitting to so there's a factual basis for the plea.
I told you you would like my question.
Okay, I agree with you. And then the court asked about excusable neglect. Well, first I want to mention, Mr. Souter argued that if DeMarion had pled guilty to the 1-year specification, that would have been a complicity spec and that would have become a discretionary. That's not factually accurate. If you look at what a 1-year spec is, that's possession of a firearm. A 3-year spec is actually using it to facilitate the offense. In either event, the person has to have the gun on them. So his argument that pleading to a different count is factually flawed because juveniles don't have that accomplice liability. And then a quick word about excusable neglect.
So
I don't
I'm going
think...
to give you about 30 seconds.
That's fine.
Okay.
Excusable neglect is not knowing the law. That's not excusable neglect. You forget, you get busy, you get distracted, that's excusable neglect. Not reading the code section, not once but twice, is not inadvertent. That's willful neglect, if you will. And the prosecutor admitted in both the proceedings to juvenile court, before it was brought to her attention, she hadn't read the code section, and even after it was brought to her attention, she still hadn't read the code section. So I think they're stuck with, it's not excusable neglect, it's almost on purpose. Thank you.
Thank you. Thank you for your arguments and thank you for joining us this morning. Thank you, Principal Gray. All right.
Thank you, Your Honor.
So you have 4 minutes.
Reserve 4 minutes.
Reserve 4 minutes, yes.
Yes, please. Thank you.
Whenever you're ready.
Thank you. The General Assembly recognized by amending this statute that however appropriate a class action might be for penalties under this statute in normal times, the first year of the pandemic was not a normal time. In May 2020, when the Voss release was recorded, 1 million Americans had tested positive for COVID and 100,000 Americans had died. The businesses that had to deal with paper were particularly affected because at that time, no one knew how the virus was transmitted and people, just as they were disinfecting their groceries at home, people were worried that they would pass the virus to colleagues by handing a piece of paper to a colleague.
Before you go on, I want to understand the timing here.
Yes.
Okay, so the General Assembly passed the amendment to 530136. Passed it in January 2023, correct?
That's correct.
The hearing was in February 2023.
That's correct.
Then the trial court granted the class certification also in February 2023.
Also correct.
The General Assembly passed, and then your client filed its notice of appeal also in February 2023? February, early March?
I believe that's right, yeah.
Okay, and then the General Assembly, the statute was not enacted until April of 2023, after the class certification and after the notice of appeal was filed.
The 90-day effective date was after the notice of appeal was filed, that's right.
Okay, thank you.
So it had been signed by the governor in January.
But it was not effective.
It was not effective, but when you look at what the statute regulates, I think that the trial court misapprehended what it regulates and did not apply it because of that misapprehension.
Well,
Can I
isn't
turn
the
to that?
trial court, doesn't it have a duty to apply the statute that exists at the time rather than what it will happen in the future?
Well, in certifying the class, it has a duty to look at, particularly given the emphasis in this class certification motion, at what damages will be available when the case is adjudicated on the merits.
But the statute wasn't effective yet.
The statute regulates the ability to collect damages, not the ability to certify a class. And because the premise of the class certification was that this class would be able to recover the statutory $250 penalty, that premise is no longer correct. No damages have been awarded. We haven't gotten to the merits in the trial court, and
But it's no longer correct, perhaps, in front of us. The issue is whether it was correct at the time that the trial court was making its determination. So we're an error correcting court. How can we, you're asking us to correct an error that didn't exist at the time of the trial court's determination.
Well, respectfully, Your Honor, we don't see it that way. We see it as an error that did exist at the time, and in fact, an error of law. Let me address that in two steps. First, let me point you to footnote 2 of the court's decision, which is where the statute is addressed. And the court says that it will not apply the statute retroactively. Right? So I think what you can see is that the statute, is the court would not have applied the statute because it believed the statute was retroactive. That's an error of law. And then the second point is that the court has a duty to look.
But why? Because the law wasn't in effect at the time. So how would the court be applying a law retroactively that wasn't even a law yet?
So the court thought that we were asking for the law to be applied retroactively. Because the law applies to the collection of damages, the ability to collect this particular type of damages through a class action, it's a procedural change that regulates a part of this case that hasn't happened yet. And I think both sides agree on the legal standard. It comes from the Buckeye Candy case and other cases from both the Supreme Court and this court, that in assessing retroactivity, it is 100% clear that a procedural change may be applied to pending cases. What you look at is what part of the litigation does it regulate. In this case, it regulates the ability to collect damages. That has not happened yet. That's why what we were asking for is for prospective application of the law. The premise of the other side's class certification motion is because we will be able to seek class-wide $250 penalties, you should certify a class. There will be no problems under Rule 23. Because the law is now in effect, the district court, like the premise on which the trial court certified the class, which is that penalty would be available, is not correct. And so I certainly understand that the law had not taken effect at the time that the order was signed, but because the order was not a order regulating class certification procedure, it's a law regulating the collection of damages. And that's why the trial court had a duty to apply it.
But it didn't exist yet. I mean, it was not effective. I'm just struggling with why a trial court would ever apply a law that was not in existence yet.
So the trial court, in doing the class certification analysis, has a duty to look forward over the course of the litigation to whether the class will be manageable, whether the class will be is the superior form of
Do you have
litigation.
any case law at all suggesting that a trial court should apply a statute that is not yet in effect?
So this fact pattern hasn't come up yet. What we have ample case law on the way that you apply, on the way that retroactivity is applied. So
I don't even want to get to that. I'm specifically talking about the fact that the trial court applied the law as it existed. Do you have any case law showing that a trial court is applying a statute that is not yet effective?
So I don't think so. I don't think the other side has a case refuting it either, right? Because what we have cited to this court is its own decision about the nature of the class certification inquiry, which is to look forward and assess how the certified class action would proceed.
Looking forward, counsel, wouldn't there have, in theory, been time to undertake actions in the case consistent with the law at the time, such as settling the case before the statute took effect? I'm not saying that that would have happened here, but in theory it could have, right?
Given the process that applies when a certified class action is settled, no, I don't think so. I don't think that a class action could have been resolved either on the merits or by settlement. Remember, there would have to be notice to the class, there would have to be a fairness hearing, and so forth. None of that could have been completed before this statute was going to take effect. And it was 100% certain that the statute was going to take effect. There was no doubt about that. This was not a case in which signatures were being gathered for a referendum to overturn the statute.
And so why not move to decertify the class?
So I think that it's certainly correct that if we moved to decertify the class today, the correct outcome would be to apply the law that's in effect today, including the amendment to C2. We read the footnote to suggest that the district court would say, well, you're asking for retroactive application, and so I won't do that. So if this court were to correct that misapprehension, we could certainly, another way to get at this would be to move for decertification rather than to reverse the certification.
That gets to my question because I think arguably there's two components here. One is the class certification, the other is the damages with regard to C2.
Correct.
Okay? So it's, you know, it's, if I understand one of your arguments, in essence, you're saying, well, the damages are going to apply, not necessarily retroactively, but, you know, it's a continually, right? So as long as there's a class action, when the damages are determined, then C2 is going to kick in to determine damages. There are no damages, right? While it's different, which is different to when the class was certified as to what's going to apply. Just, if you're following me, let me finish, okay? So it seems that maybe perhaps the remedy you're seeking it through the wrong avenue by asking us to address the trial court's determination on class certification.
Here's how I think the two are linked, Your Honor. It's certainly correct that if this court, you know, if this appeal didn't happen and we proceeded to litigate in the trial court, that the law would prohibit the trial court from awarding those $250 in penalties because to unnamed class members because the statute is now in effect. That, however, the reason they're linked is that the premise of the class certification was that this is a superior form of adjudication. There are no individualized issues that predominate, and of course we want to talk about why that's wrong for other reasons as well, our second and third issues. But the plaintiff's entire premise in moving for class certification is that classes can be certified under this statute because the penalty applies to each class member and is easy to award.
But that gets to my question a little different than class certification, because if there are no damages, is there a cause of action?
We think that certainly Mr. Voss has a cause of action because he's allowed to recover the $250 if he chooses. The only question is what procedural route he can do so. He can't do so via a class action, as the statute says, but he certainly can sue under subsection C and he can recover the $250. In fact, anyone who has a cause of action under this statute can still sue. Any relief that was previously available is still available. Just as a procedural matter, this penalty can't be awarded in a class action. And so I think that's the connection here. It's not that there is no cause of action. It's that this procedure is not that these damages are not available via this procedure. And we think the consequence should be that the trial court should not have certified the class if it's going to have to be decertified 2 months later, for example.
It's your position, counsel, that the amended statute not only applied prospectively to the approximately 3 years left of the statute of limitations, but to lawsuits like this one pending at the time that the statute was enacted. Can you walk me through that analysis, please? Sure.
So the period of time covered by the statutory amendment is plaintiffs seeking to recover the $250 penalty for calendar year 2020, so for failures to record within 90 days that occurred within calendar year 2020. So in other words, all of the conduct in question has already occurred. There are no new cases arising today that could be subject to this statute. It's certainly correct that the statute of limitations means it is hypothetically possible that there exists someone who hasn't yet asserted their cause of action from the year 2020. But we think that the plain import of the General Assembly's amendment is to deal with the cases from 2020 which are already pending. And so the question is, what aspect of those cases is regulated by the statute? That is the collection of damages. And in this case, that hasn't happened yet. If the case were final and had already gone to final judgment, we'd be facing a different question. Or if damages had already been awarded.
What in the statute clues us into the intent of the legislature to essentially erase existing claims in a class action lawsuit to the $250?
So it's two things, and we look at this question against the backdrop that a procedural change can be applied to pending cases, and I know the Ohio Supreme Court has a retroactivity case before it right now in the criminal context that deals with applying a statutory change to crimes that had already occurred before the statute, charges that had already been brought before the statute, because the relevant proceeding in that case is the trial. In this case, it's the collection of damages. So if you look at two things, actually, well, three things. One, it regulates procedure. Two, it applies to violations that occurred in calendar year 2020. And three, it prohibits the collection of damages. So in any case that involves that past conduct from the year 2020 that has not yet involved the award of damages, damages can't be awarded via a class action. That's how we see those three textual aspects of C2 telling this court what to apply and when to apply.
Well, maybe I'm not being clear. I mean, the legislature would have known, I think, that there were pending lawsuits like this one,
Yes.
seeking class action damages for the $250 for not recording on time. And it passed this statute, presumably understanding that it could have potential impact on existing lawsuits that were already in court. But the statute is silent as to its impact on those cases. What are we to do with that?
I think that you're to apply the well-established retroactivity doctrine, which looks at what kind of change did the legislature make. It wasn't a substantive change, it was a procedural one. There's no presumption against applying procedural changes. There's no clear statement rule for procedural changes. You apply, the trial court will be, when it comes time to award damages in this case, will be obliged to apply the law without saying, well, it did. I was not told by the legislature to apply this to pending cases. In other words, the filing of the complaint is not a relevant time for purposes of the state's retroactivity doctrine. So I think it's that backdrop that answers your question.
In their brief, your opponent raised a claim that this is really affecting a substantive right, in part because they expended significantly more money, something in the nature of $5,000 and upwards of that, in pursuit of a class action for what you're now saying is limited to an individual $250 action. Can you address whether the pursuit of such a small claim and the expenditure of extreme resources in pursuit of that claim confers any substantive right on the plaintiff?
Well, just as if you had, if a litigant had retained experts to prepare for a trial in which it thought it was going to bear the burden, and then the legislature changed the burden of proof before that trial, and ultimately it is for the legislature to do the interest balancing about whether this class action procedure is the right form in which to recover these damages and when to make that change effective. The default is that a procedural change takes effect when it takes effect. In other words, it doesn't grandfather in existing actions. Now, to the second part of your question about whether it can be economically feasible to recover, I mean, recall that you can, even in an individual action, you can still recover costs if you're the prevailing party. And if it were correct that there was no defense to this liability, then these cases might well not proceed very far. In other words, like if it really were as strict a liability, a form of liability as our friends on the other side say, then there would be no point in spending fees to defend it. Now, of course, in this case, the context is quite different because it was the first year of the pandemic, and we think that the defense that we've raised would have to be resolved based on individualized evidence, and we certainly could turn to that, but I don't want to get off your question really if I haven't answered it fully.
Thank you.
I'll give you 30 seconds to wrap up.
Thank you, Your Honor. Just to touch very briefly on the other two issues, we of course have arguments that the trial court erred I'm going to do it in 30 seconds, Your Honor, that the trial court erred in granting the certification. If if this court were to take up those arguments and hold that, for example, the individualized nature of the pandemic defense, or as in the Felix case, the inability to show injury on a class-wide basis, that's a basis for vacating or reversing the class certification decision. And this goes back to Judge Bach's first question to me. If you vacated or remanded the class certification order and told the trial court it would have to do it again, which we think would be appropriate, at that time it would also be 100% clear that the statute, the amendment to C2 is now in effect and would govern any proceedings on remand.
Thank you.
Unless the court
Morning, Your Honors.
Good morning.
Nobody in the audience will get this reference. Try to avoid it if you like.
Good morning.
May it please the court, Bill Markovitz on behalf of the plaintiff appellee and Sam Voss. I want to start with a point you raised, Judge Zayas, which is that this is an error-correcting court. And the basis of jurisdiction in this case is 2505.02, which allows this court to review for error the grant of class certification. What is the error that defendants are asserting took place here? It's simple. They're asserting that the trial court erred by refusing to apply a law that was not in effect.
Make sure you talk, because the students really want to hear what you're saying. They came here just for you.
Go back to a little taller. The assertion by defendants is that the trial court erred by refusing to apply a law that was not in effect. On this issue, we think this court should apply a rather uncomplicated rule of law, which is that it's not error to apply the law that's in effect at the time. But page 6 of our brief, we cite a number of cases that hold that. They say nothing to the contrary. That is the law in the state of Ohio and around the country as far as I'm aware. So let's turn to whether or not this law is being applied prospectively. Because what they say is this is a procedural law. We disagree with that, but they say it's procedural, and that procedural laws are considered to be applied prospectively, and that's generally true. But it's only true when it's applied to proceedings occurring after the effective date. Conversely, if it's being applied to proceedings before the effective date, that's a retroactive application. And on this issue, defendants' arguments are fundamentally and spookily inconsistent. I had to work in a Halloween reference. Because on the one hand, as you're hearing here today, they say, oh, this amendment, it only applies to the recovery of damages. And that's in their appeal briefs. But in their motion to eliminate class certification that they filed shortly after this amendment passed on January 6th, they said the contrary, directly the contrary. They said that this amendment expressly, clearly, unambiguously prohibits class certification. We agree in large part with that view after its effective date, assuming it's valid. If a class certification proceeding were taking place today and that amendment was found to be valid, you could not bring a class action seeking statutory damages for $250 involved in the year 2020.
So, Mr. Markovitz, if I'm understanding you correctly, what you are saying is that their argument that because there has been no ruling on damages at this point, that, so you're saying that that argument is wrong because the class has already been certified, even though there has not been a collection of damages yet?
Even though there hasn't been a collection of damages, that's not, the question is, what phase of the proceeding are they asking that this apply to? They're asking that it apply to the class certification phase, which took place before the effective date. That makes this procedural rule retroactive, not prospective. And if it's retroactive, procedural rules can be applied retroactively, then you look to the legislative intent. And what did we hear about the legislative intent? Well, it must have been clear since they used the 2020 that there was a retroactive intent. That's not the way the law in Ohio works. Federal law has somewhat of a relaxed standard on retroactivity, and if it's reasonable, federal laws may be applied retroactively. Not so in Ohio. Constitutional provision that prevents the General Assembly from passing retroactive laws.
Well, counsel, I think they're making a pragmatic argument, which is why certify a class that's never going to serve its intended purpose? If the class cannot ultimately collect the $250 damages, why certify the class in the first place? In other words, we know this issue is coming, and it's coming actually quite soon. So what is the point of the class?
I do assume that if this court affirms, as we believe it should, there will be a motion to decertify. At that point, we believe that motion to decertify will be denied. Because once you properly certify, once you say this amendment can't be applied retroactively, and I can certify a class for statutory damages, you don't then take it away. And even the cases they cite say, even when you're talking about a procedural rule, you don't parse it out. You don't give it over here and then take it away after appeal or on remand. The Landgraf case, Supreme Court
So
case.
if this case was to proceed, what would happen at the damages phase?
The damages phase, the damages would be awarded because the amendment did not apply when the class was properly certified to pursue statutory damages.
But at that time, the damages are being determined, or you're saying that C2 would not govern at that time?
Yes, that's exactly what I'm saying, Your Honor. C2 would not govern because a class seeking statutory damages has been properly certified, and the right to those statutory damages can't be later taken away. Again, Landgraf, if you look at footnote 29 of the U.S. Supreme Court Landgraf decision, paragraph 24 of the State v. Pitts decision, which was a first district case, they all talk about, well, you don't just undo things that have already been done. There's still a pragmatic approach. And once you certify this class for statutory damages, that sticks. That's the argument we'll make on the motion to decertify that I assume will be coming.
So what you're saying, in essence, is when the class was certified, it was premised on an opportunity for the award of damages that was to play out a specific way, absent of C2 at that moment,
Correct.
right?
Yes.
And despite the language of C2, because of the requirements of what had to be considered in the class, in the certification of the class, it cannot be revisited.
Correct, Your Honor.
I'm sure they're going to feel differently.
They will feel differently, but that's something for the trial court to work out. When I read their brief, to some extent, it looks like they're asking this court to give an advisory opinion, which is not appropriate.
With regard to damages.
With regard to damages and what's going to happen if they move to decertify. That's for the trial court to rule upon.
So you would ask us to, if we were to rule in your favor, to rule narrowly
Well,
and to just,
advisory opinions are not within the jurisdiction of appellate courts. And so, yes, I would ask that this court rule narrowly that the trial court, which we believe got it right. But let me touch on this the question of legislative intent, because that's where I think the defendants go far, far astray from Ohio law.
and I'm gonna rephrase I'm gonna add, I wanna go back before you go forward,
Sure.
okay? Because I'm thinking this through, all right?
All right?
It sounds to me that if we were to rule in favor of the appellant, that we would be addressing an issue that wasn't before the trial court.
Yes, you would be. And I don't think the issue is what should she, if you're talking about what should she do in terms of damages down the road, that wasn't before the trial court. The question was it properly certified at the time, which it was. Again, because you can't apply this law retroactively. And the reason you can't is primarily because of this issue of legislative intent.
So I'm gonna go back to what I just said,
All right?
and it goes back to where I was with the appellant's argument, which is this the proper mechanism? Because if we are being asked to consider something that wasn't before the trial court on appeal, is this the proper mechanism?
I don't think it is the proper.
If there are any deficiencies that were created by C2, is this the proper mechanism?
No, again, because we think that C2 did not apply.
What would you say would have been the proper mechanism for the appellant?
To raise the issue of, is the trial court going to have to decertify? A motion to decertify before the trial court. Because that's the appropriate body to make that determination on whether her correct determination that the class should be certified under the existing law of Ohio, now that the statute has taken effect, should be revisited. We say no. But that's going to be for the trial court to decide.
Can you address the standing argument that's been raised?
Yes, Your Honor. 2 points on that. There's common law standing and there's statutory standing. They say there's no injury that supports common law standing. But the law of Ohio differs or disagrees with that argument. Rosette. In Rosette, the Supreme Court said that the $250 are statutory damages, not penalties, damages, as they say, as it says in the statute. The Cleveland Mobile case 2 years later said they're akin to liquidated or stipulated damages. They say, well, wait, let's look at Raddatz. They happened later and said there's a punitive aspects to them. And that was with regard to a federal law on whether you could collect damages against Fannie Mae that was in receivership. And the court there was very careful to say, we're not overruling Rosette. We're just finding for the purposes of this law that there's a punitive or penal aspect to the $250. They're both compensatory and punitive. They cited a case in that opinion dealing with employee-employers, statutory damages, and saying, look, as to the employee, it's compensatory. As to the employee, it's punitive and a deterrent. The same analysis applies here. As to the mortgagor and the current owner, it's compensatory. As to the mortgagee, it has some penal aspect to it. It's intended to be a deterrent or to encourage them to comply. So there's common law injury to begin with. And second, there's
Can
statute.
we pause for just a minute? I want to make sure I understand what you're saying.
All right.
So because the $250 amount in the statute has some compensatory aspect to it, injury to the plaintiff is presumed? Is that your argument?
Well, there is injury. I think that the recognition that the recognition by the Ohio Supreme Court that there's a compensatory component to it is based on a couple of factors. The Pinchot case in the Supreme Court, which says there's a cloud on the title as long as it's not released. And then also there's cases, and we cited one, that, you know, when you have a lien, so even though there's no cloud on title for the person who sold the house, when you have a lien, that is damage. Now, it's difficult to quantify, and that's why Cleveland Mobile said it's akin to stipulated or liquidated damages, but there's injury. And so, under the law of Ohio, there's common law injury, but even if there weren't common law...
I just want to pause and drill specifically into this.
All right.
So what is the injury? Because your opponent is arguing that your client doesn't have any injury. And they're citing to testimony in his deposition, and I'm going to paraphrase, where he said he really didn't have any, that nobody had looked at his documents, that, you know, no one had come forward to say that there was some problem, you know, nothing specific had come up financially for him as a result
His
of this.
neighbors didn't shun him. He could still lift
Yes.
weights. There were all questions like that.
Exactly.
It went on for 6 hours.
So
Correct.
is it because there was this just dangling, unrecorded, transaction that we assume that there's some kind of injury and the statute allows that, or what is the specific common law injury that he has?
The common law injury is akin, there is an injury. Cloud on title is an injury. A lien is an injury. In the case we cite, recognizes a lien is an injury because it's telling the world that there's a debt that you have that you don't have. So those are injuries. And that was recognized by the General Assembly and recognized by the Ohio Supreme Court in their Rosette decision and in the Raddatz decision. They want to take the position with Raddatz that it means that, well, sometimes it's punitive, but sometimes it's not. That's not a fair reading of Raddatz. It's always compensatory in part and punitive in part.
And does someone have to know about this? I mean, there's that quirky line from the case, you know, if the tree falls in the forest and no one hears it. I mean, if the documents don't line up but no one sees that, is there an injury?
Yes, in this case, this is more akin, we think, to a trespass type injury, but that's attempting to apply a TransUnion type analysis here, and TransUnion hasn't been adopted by the state of Ohio, nor do I think it should be, but it has not yet been adopted. But even if there were no common law injury, there is still statutory standing. And there's statutory standing because the statute could be no more clear that there's statutory standing. It says, and they cite Progress Ohio and Ohioans for Concealed Carry to say, well, wait, it's silent as to standing. Those cases stand for the proposition that if it's silent as to standing, there's no standing. No. Those cases stand for the proposition that if it's silent as to who has standing, there's no standing. But here it couldn't be clearer. A mortgagor, it was even amended in 2015 to say a current owner has standing. And so there's statutory standing here.
So it doesn't matter whether there's any injury, because there is, you're arguing, there is statutory standing, because the statute says may recover in a civil action damages.
Exactly.
So what you're saying is that whether there's an injury is completely irrelevant because there's statutory standing?
Yes. Even if there were no common law injury, we believe there is, there would still be statutory standing. And it's still the law in Ohio that you can have statutory standing without injury. There are some cases, and this is what may confuse the issue, there are some cases where statutory standing incorporates other requirements such as injury.
And am I wrong to say that that came from federal law?
Then what came from federal law?
requiring both statutory and common law, if there is statutory standing, that there must be an injury as well.
Yes, they're trying to inject federal law, and even as the case they cite, the Smith v. Ohio OSU case, says this is where federal law and Ohio law diverge. There is no injury requirement for statutory standing for more than 100 years in Ohio. And that's still the law. There's even a statutory standing case in the Supreme Court this summer, a disqualification case, that was statutory standing for an attorney who had no injury, but was bringing a suit to disqualify a judge on behalf of a client, and statutory standing is found. You can have statutory standing without injury in Ohio. And if I can quickly turn back to the legislative intent for a second.
30 seconds.
I thought I was running close, but I did want to get out the point that...
I'm going to keep you basically to your 30 seconds.
All right.
Okay.
That I wanted to emphasize the difference between our positions on how you judge intent. We both cite Heil v. Porter, a Supreme Court case. We cite it for the proposition that it has to be clear, it has to be expressed, it can't be inferred, and that Rule 1.48 of the Ohio Code applies for statutory construction, which is a presumed prospective unless expressly retroactive. They cite Heil v. Porter as well, both in their brief and their reply. They cite it for the proposition that you don't need magic words or talismanic phrases, and that general rules of construction apply. The difference is we cite the majority opinion, they're citing the dissenting opinion.
Thank you.
Thank you.
You do have your 4 minutes.
Thank you, Your Honor. I appreciate that. I'll just touch on two subjects, one to do with the statute and the second to do with standing. First, on the statute, I think we heard about two different versions of the trial court's order from Attorney Markovitz. On the one, a narrow decision that didn't reach any of these issues, and he urged the court to not reach them because the trial court had not reached them. But second, a very powerful and robust order that will prevent the statute from ever applying to this case. I mean, the answers my friend gave were that because the certification order, the order that's now under review, predated the effective date of the statute, now the statute can never apply to this case. There is no authority for that in Ohio law. There's no retroactivity doctrine that would justify that. So it's one thing for him to say we should litigate the effectiveness of this statute in a decertification motion. But the other side of his position is that there can be no decertification motion on that basis. It's now too late, and the only way to fix it is through reversing this order.
Well, that's not what we're reviewing, though, at this point. I mean, we're not reviewing a decertification motion because that doesn't exist.
I agree, but what my friend on the other side said is that the order that you are reviewing, which is the certification order, that was the last train to leave the station. Once that certification order is in place, the statute can now never apply to this case. We don't think that's correct, and if you said that that's not correct, then we could go and move for decertification and hash it out in that forum.
But the reality, if we go there, then we're addressing something that wasn't before the court. So how do you address my questions with regard to, in some ways, your argument is also asking us to address things that weren't before the court?
Well, what effect to give the statute in the class certification was before the court, and the court said it would give it none. And I think that just a couple of examples, and Judge Bach, you asked me in the opening argument, do I have authority? I think, let me try and give you a couple of common sense examples of where you might look to.
And you're basically relying on the footnote.
That's the only place the trial court addressed it, that's right. And the trial court said no retroactive application is permitted, and so I'm not applying the statute here, it hasn't taken effect. Those are two different rationales, and if you corrected the non-retroactivity point and said either that the court should have taken cognizance of the statute at that moment, or that we are free to address it through decertification, like those are two ways of getting at the same issue. But if a statute were about to take effect in 10 days, and a plaintiff came in and sought a preliminary injunction The district court, I think, would not, or the trial court would not grant the preliminary injunction and say, you're likely to succeed for the next 10 days, even though by the time we could try this case, the statute's going to be repealed. Likewise, if a criminal statute were about to be repealed, you wouldn't ignore the repeal of the statute in granting or denying
Perhaps the trial
bail.
court would stay it.
That's absolutely right. That one way of avoiding some of these issues would have been if the trial court had not entered the order until after. Now, I think our friends on the other side would still say, well, it was too late once we moved
Was there a request to
it.
stay?
We did request to stay in our papers bringing this to the trial court's attention. So I think those are the points I wanted to make about the statute, and just quickly on standing, if I still have.
You have 30 seconds.
Excellent.
We do have students that eventually have to go back to class.
Absolutely, Your Honor. I won't use any more than the 30 seconds. I just want to quote back the thing that Attorney Markovitz said, which is that there is no cloud on title for people who sold the house, right? So half the class, no cloud on title injury, and then the whole colloquy about whether having this on the record suggests that you have a debt that hasn't been repaid. Mr. Voss is the buyer. He didn't have a debt, right? In other words, this is about recording the discharge of the loan from the person who sold him the house.
Can you please address, so I know what federal law says about needing to have an injury in addition to the statutory. And there is case law saying that Ohio diverges. So the statute says that the owner or the mortgager may recover in a civil action damages. Can you explain to me how that doesn't confer standing?
So, two responses, and I know I'm out of time, and I won't press my luck here. So first, I would suggest that you look at the Estate of Mikulski case. There are two. I believe it's the one from the 6th District, which adopts the Supreme Court's decision in Spokio, a precursor to TransUnion on this point, that says that Felix and the requirement to show injury across a class adopts this federal law principle. And then the second point is that the statute uses the word damages. Damages are awarded to people who are damaged. We think that that's where in the statute you see that this statute doesn't rebut the presumption that we require a common law injury.
Why would the General Assembly enact this statute and make a private cause of action if nobody would have standing but for an actual real injury, such as somebody seeing that there was a cloud on the title?
I don't think it would take that much to have injury. Having to take time out of your day to call the 1-800 number that's available. This is detailed in the expert report attached to our class cert motion. Like the things that you might do if you found this cloud on your title. It's very easy to fix. We're not saying that you wouldn't be injured even if you had to take time out of your day, even to do one of those easy fixes. But during the 22 days that this passed the 90-day period that this remained on Mr. Voss's title, he didn't do any of them. He didn't even know about it.
Thank you.
Thank you.
Thank you.
Thank you both for your arguments this morning.